Hi everyone, welcome to Active Self-Protection Extra, here again today with defense attorney, judge pro tem, former prosecutor, Arizona Ranger, and all-around good guy, Tim Forshee from Forshee Law. Listen, we're going to talk today about something that I think just wraps some self-defenders around the axle, and it really shouldn't, and that is case law. Firearms Legal Protection is who I trust to help me after a use of force incident. If you're a Firearms Legal Protection member, you can attend our monthly Active Self-Protection training seminars for free. Check out all they offer to their members at the link below. So I hear this all the time. Well, you know, John, in this particular court case, this thing happened, and they appeal to case law for things. Yeah. And I don't think most people understand case law real well.
Including a lot of lawyers, probably. So probably including me, to be honest. I mean, it's very complex. I mean, the first year of law school, that's what you're really studying is case law. All you do is read briefs. You read case law, case after case after case after case, and you brief them, and then you discuss the concept of stare decisis and what that actually means, and the concept of common law. And it's hard. I mean, that's probably one of the things that screen law students out more than anything else. Yeah.
Well, and let's think about the fact that so what most people maybe do or probably don't understand is before we even get started in this, you have to understand how the legal system is built. Mm-hmm. So you have a local system, you have maybe a county system, you have a state system, and then you have a federal system that's broken up into districts.
Well, and it's even more complicated than that because you've got a state system and a federal system.
Yeah, and they're side by side.
They're two separate systems,
yep.
And there is overlap. If there's a constitutional issue on the state level, then that can become a federal issue, et cetera, et cetera. But again, it's even more complicated than people think in that respect. Yeah, but the easiest way to define it is you've got a trial court, an appellate court, and a Supreme Court. It's almost always going to be three levels, right? So most of the time, I mean, I've argued one case in front of the Arizona Supreme Court, and I think 2 or 3 in front of the Court of Appeals, and I don't like it. I just don't like it. The pressure's high, and you're making case law. You're making case law.
So that's where it is. Trial courts
don't make case law.
law.
Only appellate decisions. Yeah. And a lot of appellate decisions are unpublished, and you can't use them.
So they'll make a decision, and they will say this is a non-precedential decision.
Yep.
So what the trial court is doing is determining how the facts fit a series of laws.
Well, the trial court looks at the law first, right? The trial court is known as the finder of law. The jury, or if it's a bench trial, it would also be the judge, is the finder of fact, okay? So the facts are determined by the jury, the laws are determined by the judge. So the finder of law is going to look at precedent. The jury won't hear any of that. The jury will have jury instructions that flow from case law, but they won't know that. They're just reading a jury instruction.
Jury instruction is supposed to be a translation of the law from lawyer into English.
And that can be if it's a very simple issue, it can be just basically the statute.
Yep.
Or it can be the law as it has been determined by appellate courts in case law, correct? That's what the jury knows about. The judge and the prosecutor and the defense attorney are the ones that are arguing the actual application of case law. Where this usually comes up is in a motion in limine or some sort of a pretrial motion to exclude, something like that. And that's where all the case law arguments come into play. Your Honor, this case argued in this same court 22 years ago, blah, 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 these are the facts. And that court ruled that. And so this court is bound to follow that decision by the legal concept of stare decisis. One of the rare times you get to talk Latin.
Stare
decisis means it's...
Remember, if you want to sound important, say whatever crap you need to say in Latin.
Throw it in Latin. It just basically means already decided. So it means precedent. So if this was decided, then now there are cases that are known as precedent-setting cases where we change that. We see that with the Supreme Court primarily, where this has been the law for years and years and years. There were many, many years in this country, I'm embarrassed to say, where African Americans were counted as 3/5 of a human being.
Terrible.
And the Supreme Court decided that in the Dred Scott case. So you've got a constant evolution of case law, but common law is always changing. It's supposed to change in regards to our society, mores and norms and that sort of thing. Hopefully it does, but it also you don't want to change things too fast or you wind up with backlash. Some people might argue that the Roe versus Wade decision was too fast. And as a result of that, we've seen backlash, whether you agree with that or don't agree with that. What's changed? Nothing except the times that we live in and 40 years of case law. So
when the trial court is really about the finder of law, the judge, and the finder of fact, the jury.
Which can also be the judge if it's a bench trial.
Sure.
Right.
Let's just say it's a jury trial.
Sure.
Okay. Now the facts here, they're established. The case has been established. But if one side or the other, depending on a civil case versus a criminal case, they say, wait a minute, the finder of law screwed up here. Something was not right here. This law was misapplied. Then they appeal it to another finder of the law.
Right.
To the higher one, an appeals court.
The defendant can appeal.
Right.
The state can't appeal.
In a criminal
the
case.
state cannot appeal an acquittal. That's correct.
Right,
Yeah,
right. So that one bite at the apple,
Yeah,
as it were,
right.
right? So then the defendant says, hey, wait a minute, they convicted me, but the finder of law did wrong.
Correct.
And so then the appeals court is the one who puts out a decision that says, yes, the finder of law did wrong. The judge screwed something up here, whether that's didn't give an instruction they should have, gave one they shouldn't have, allowed some evidence they shouldn't have, didn't allow.
A Batson violation in jury selection, whatever it was, yeah.
Whole bunches of things. We had a procedural foul here, right? And so then the appeals court that can then say, got to go back because we had a foul.
And a lot of people don't understand this. A lot of people think that, well, that means I get another trial at the Court of Appeals.
No.
Or a lot of people think, well, that means I'm free, I won. No, it means the case gets remanded for redetermination back down to the trial court level. You start over.
Right. And many times in criminal court, then the prosecution will say, given that we lost that, we're not going to win this, and so we're going to
They might, if it's a politically charged case, they often won't. Oftentimes they'll offer you a more attractive plea. They might drop the charges, but especially if it's a high profile case, generally I think it's probably more like the third or fourth trial that they'll talk about that. So yeah.
Now then, this happens in state court, and if the appeals court says no, it was fine, this was good, well, you can appeal it one more time to the state's Supreme Court, and the Supreme Court gets the last say of it. And the Supreme Court is not final because they are right; they are right because they are final.
Exactly, and and the appellate courts in Arizona are only 3-panel people. So it's both of mine I've lost, but I lost 2-1.
Yeah.
And so it just makes you feel like, what could I have done? It's so
Could I
close.
have?
Yeah.
So
but
now
yeah.
you've got the state court thing, but then you have this whole separate federal court thing, because I know some people say, well, wait a minute, the state Supreme Court said, well, that, if it happened here in Arizona, for instance, is great for the people of Arizona. That's controlling on the people of Arizona, but not the people of any other state, because their state laws are different.
Right.
Now we have this whole separate federal system, which is divided into different circuits.
So we have district courts,
Yep.
At least one in every state, and then we have circuit courts. The circuit courts, that's the appellate level. So those are broken up into the different circuits around the United States. We're in the Ninth Circuit, okay?
Yes.
And the Ninth Circuit has a reputation as being very, very liberal.
And ginormous.
And it's
way too big.
Way too big, populous and area, way too big. And the Ninth Circuit is seated in San Francisco.
Yeah.
And so you get some, and it's not just the liberal versus conservative, because I don't care if anybody watching this, politics shouldn't matter one bit. But the Ninth Circuit is known as the crazy court. They just have some really strange rulings going back 50
and it's
years.
coin flips, man. You never know.
Really strange stuff, and you go, they could not possibly decide that. Oh yeah, they did. They decided that. So really, and again, it doesn't have to do with politics, but that's binding law. Now here's where it gets interesting: is when we have split circuit court opinions. So we have bump stocks that were banned by an executive order, and we have one circuit court that has said, "Yep, that's unconstitutional. You can't do that."
Not going to be.
We have another circuit court that said, "Nope, that's okay." Now what happens now?
And so now we're going to appeal to the Supreme Court.
And
right?
then what happens, and this is known as the Supreme Court would grant what's called certiorari, which is what the Supreme Court calls a review of a lower court ruling. So there are times, believe it or not, when we have split circuit opinions and the Supreme Court denies cert.
Right.
And so,
Nope, y'all deal with it.
good luck. It's legal in this part of the country. It ain't legal in this other part of
And
the
that's
country.
it.
That's how it works.
So just because, I live in the Ninth Circuit, and the Ninth Circuit rules one way, somebody who lives in the Second Circuit, well, guess what? Doesn't apply to them.
Right.
Unless it's, so Supreme Court applies to everyone.
Which is supposed to happen. But if it's a political hot potato issue, the Supreme Court will deny cert and just say,
And now I had the reason I wanted to talk with you about this
Sure.
one, Tim, is I had somebody say, well, John, it's a private citizen. So how does things like Tennessee versus Garner and, Graham versus Connor apply to my use of force? And I said, it doesn't. Well, why not? It talks about the use of deadly force. No. That's the Supreme Court deciding about a police officer acting in their official capacity and the reasonableness of them using deadly force on a fleeing felon.
Now that doesn't mean it's not applicable to a private citizen. The concepts can still be applied, right?
However,
you're never going to have exactly the same facts, right?
Right.
So yeah.
However, they're argued at law enforcement and they're used in the training and the application directly of law enforcement.
Right.
So it only applies to private citizens in a kind of a tangential
peripheral
manner.
way, yeah,
peripheral
exactly.
way. So, and the other part of that is that I've seen case law that has come into play that has nothing to do with self-defense and self-defense cases, but has some ancillary bearing on it.
Right.
And so what I want you to catch out of this, case law is stinking complicated.
And it's, in a way, it's kind of like fun. I'm almost afraid to say that, but in a way, it's almost fun because, especially your first couple of years as being a lawyer, if you work for a large firm like I did, you're writing briefs. Of course, I was back in the old days when the computerization was not nearly what it is now, but you were writing briefs and you were actually, you were asked, okay, our client did this and we need to justify it. So go research it and tell me how we can justify it. And you'd spend 30 hours with your nose buried in law books trying to find precedent from all over the country, preferably in your area, but if need be, you'd branch out and find it wherever you could to try to analogize what your client did as being approved by case law. Yeah, so, and man, it's almost like a detective process. I mean, you're really trying to just pick, well, this really isn't on point, but this little thing here will help. So you grab that, and then you find another case where this isn't really on point, but this fact might help, and you grab that, and you're just trying to get crops to grow, basically.
What the attorney's doing is looking at a fact in the case, or looking at an angle that they can use in their argument, and going and trying to find, has a court agreed with me that this is an acceptable argument?
That's right. And there's a hurricane coming, I'm trying to brace up my building so it doesn't blow down. So if I can tack a couple 2x4s on here, that's better than not. So.
And now, so again, you've always asking the question, is this about state law or federal law? Because I got to be honest with you, the federal stuff can come in and override state stuff.
Especially on a constitutional issue.
But state stuff doesn't go override federal stuff. That's a one-way street.
Yeah.
So okay, my state law is one thing, but I might bring in federal stuff that says, you might say that as a state, but that's not allowed because it's a violation of someone's rights.
Yeah, if it's a Title 42 violation of civil rights, then that puts you, so basically if it's going to be in the federal system, it's going to be a federal law.
Right.
I mean, we're focusing more on the criminal aspect here. Right. So it's going to be a criminal law. Somebody was charged with a federal crime, they were convicted, they appealed it. Now we have appellate circuit court decisions that are case law that we can use in a federal case. The other place you're going to see it is in some sort of a constitutional matter that comes up in a state proceeding. So the cops went in and they kicked this guy's door down without probable cause. That's a violation of the Fourth Amendment. That's a constitutional issue. Now federal law will apply. Exactly. So you can apply federal law in the state level, but like you said, you can't really apply state law at the federal level. Now, I never say can't. There might be some sort of precedent that the federal judge might care about, but you're right. I mean, it's clearly superior to the state courts. Yeah.
My whole point is this. Just because some case law exists, you're not positive how it applies. Be very cautious in it because it's a complicated issue.
Yeah.
And that is why you pay your attorney hundreds and hundreds of dollars an hour to go and do that work because they know the context and they have the deep well of knowledge for it that you and I, as subject matter enthusiasts, do not. And even when I'm looking at this stuff, this is when I call the attorney and I go, hey, I'm looking at this thing. How does this apply and where does this go? To let them give me some knowledge on there. So complicated issue. I'm not trying to say any one particular thing about self-defense, but even we're seeing this come down now as the New York State Rifle and Pistol Association v. Bruin is...
Best 2A case in my lifetime.
And as it's trickling down, we're still figuring out how it applies. And it's going to be a decade.
We will be for years, yeah.
I mean, when you combine Heller with McDonald with Bruin, now you've got this like, what's that going to do? We're going to see it play out in courts for the next 10 to 15 years as they figure all that stuff out. I know it gets complicated and frustrating for folks. Me too, because I'm like, well, this is pretty clear. Let's wipe all these stupid laws off the books and get it done. Well, start filing the lawsuits, everyone.
And I got news for you. If any lawyer ever tells you it's not complicated and frustrating, they're lying to you as well.
They are
lying. And by the way, a lot of people are impressed when you watch a TV procedural show about lawyers on TV and they start rattling off case law. Well, according to blah, 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 decided in the second, da, da, da. I don't know of any lawyer that does that. I know a couple of them that can do a little bit of that, but they have no life. They have no family. They have no hobbies. All they do is live in the library. They're not people that I want to hang out with, right?
That happens when you watch Law and Order.
Oh, all the time.
Not when you're in the
railroad. I always am reminded about a great quote from Einstein. Somebody asked Einstein about why he had to look things up, and he said, "Why do I want to have things in my brain that I can go find in a book?"
Amen.
I'm not going to memorize that stuff. I got other things going on. But I know where to find it.
So listen, when you want to know case law, that's when you call the attorney. You let them do that stuff. Those of us sleuths on the side, subject matter enthusiasts, not going to be as helpful as you think.
And if any of us subject matter enthusiasts need to find case law, you got problems. You might do it just as a hobby, but if you need it, you got a problem. So let's hope you don't.
Listen to him.